Altman is a Long Beach-based attorney focusing on creditor-debtor relations, including bankruptcy and assignments for the benefit of creditors, focusing on commercial and real estate litigation. Let's meet Louis Altman. Hello, Lou.
Hello,
Thanks
Taylor.
for coming in.
You bet.
Please sit down. So, Lou, tell me, how did you get into this area of the law?
I started practicing in Texas at the time that oil was going down and real estate was going down, and it was the center of the universe for bankruptcy practice, creditor-debtor relations, people who were trying to get out of debt that they got into for bad reasons, or were trying to defraud their creditors by, in one case, hiding gold bullion in the trunk of their car, going out at night and taking oil rigs and parts, taking them somewhere. So it depends on which side. At that time I was working on behalf of a bank. Sometimes now I work on behalf of the debtor who just needs a fresh start, isn't doing anything unfairly, incorrectly, just needs a fresh start, made a bad business decision, and I want to get out.
Now, you mentioned the term, or at least I mentioned in the term in your introduction, that you were involved with the assignment for the benefit of creditors. What's the difference between bankruptcy and assignment for the benefit of creditors?
Bankruptcy is federal law that is always filed in a federal bankruptcy court. An assignment for the benefit of creditors is a state court analog or similar relationship, except it's in a state court instead of bankruptcy. Why would someone, for example, want to use an assignment for the benefit of creditors instead of a bankruptcy? Number one, many times a new business venture, a board, a loan application will ask, have you ever filed bankruptcy? Well, if you do an assignment of benefit of creditors, you can truthfully say, I have never filed for protection under the bankruptcy code, and I've never had a business that filed for protection under the bankruptcy code. The costs are similar, the effects are similar, because in an assignment for the benefit of creditors, or ABC, all of the creditors have their claims adjusted. I have $1 million claim against the debtor. The debtor has $100,000 in assets. I get paid 10 cents on the dollar. In a bankruptcy, in a Chapter 7 bankruptcy, virtually the same difference. The other difference is, let's say I own a company that has some machinery or photographic equipment or something else that I want to buy and start a new business. Then what I can do is, in an ABC, I go to the assignee and I say, I want to buy these things and I'll pay fair market value. And the assignee will sell them to the former owner of the business, who then uses that equipment and starts a new business. If you file Chapter 7, the trustee may take months to sell all this equipment. If it needs to be serviced, if it's a truck, if it's something that just shouldn't be sitting out, you may never be able to get that asset back to start a new business. Obviously, if you want a reorganization, that has to be in bankruptcy. And if you want a Chapter 13 wage earner, that has to be in bankruptcy in the federal court. That's the only remedy. An ABC is only for a business in California, has to be a California business that wants to liquidate its assets, pay its creditors, and be done with it.
And business only, not personal.
Great question. Yes, business only. An individual, if he has no choice but to throw up his hands and say, I can't pay my creditors, only federal law will work.
Well, it's still fascinating that you not only brought this topic up, but you are probably, I think it's fair to say, an expert in that area, that ABC, the assignment for benefit of the creditors, because just that one thing alone, as you said, you're going to be asked again, have you ever filed for bankruptcy? And to be able to truthfully say no, and yet still reap the same benefits, or it sounds like very close to the same benefits, what a if I may say, a brilliant idea.
Well, the California legislature set it up. Very few people know about it. There are a few people, there are probably no more than a dozen people in Southern California who do that kind of work. Say, yes, come to me, we can set this up, you don't have to go into bankruptcy. Some people think it's a personal stigma to say I filed bankruptcy. Forget the loan application, forget being on a board that says, have you ever been in bankruptcy? Some people think it's a personal stigma. It's like, I'm conceding I failed. Well, an assignment for the benefit of creditors has a different feeling to someone who says, I didn't fail, my business didn't do well, I had a creditor who was unfair, the economy went downhill, all sorts of reasons, but I've never been involved in a business that filed bankruptcy.
Well, what sets you apart from other attorneys who practice in this area?
I've been doing it a long time. A bankruptcy as opposed to an ABC, and for example, if there's no bankruptcy, let's say there's just a dispute between a creditor and a debtor, many lawyers, but particularly in the bankruptcy context, many lawyers have never tried a case to a jury. If you are if you're entitled to a jury trial, and in a bankruptcy case, many times a creditor is entitled to a jury trial. You have to know how to A, ask for it, B, demand it, C, make sure you don't waive your rights, and finally, you better be able to try the case to a jury. Many debtors' lawyers, this would be if I'm working on the side of someone who has a claim against a debtor or a claim against the bankruptcy estate, or more specifically, the debtor is suing my client for enough money to make it worthwhile, and my client says, wait a minute, we didn't agree to be in bankruptcy, you sued us. We have a right to a trial by jury. Many debtors' lawyers are either confused or frightened to try a case in front of a jury. And many bankruptcy judges have never tried a jury trial. So they will assign the case to the district court where the case gets tried. Sometimes there's delay. But that's something that I have done in a bankruptcy context, and I know how to do it, and some lawyers who practice bankruptcy work really don't.
Well, that's a great benefit to your client, whether you actually go to trial or not, because they'll likely, if things do settle, they'll probably get a better settlement because of the threat of going to trial if they're not treated right.
Exactly, because a debtor's attorney wants to keep the costs down, because the debtor's attorney knows at the end of the day there's this pot from which he or she gets paid. If that pot shrinks too quickly, then they're not going to get paid.
Well, what are some of the more challenging cases or issues you've dealt with?
These could involve, for example, a case in which, and this happens in any dispute, one side wants a pound of flesh. I don't care how much it costs me, I'm going to the Supreme Court, I have a lot of money, I hate you, I want a pound of flesh. Those are difficult cases, and sometimes we have to show the other side we're prepared to go as far as you are. You want to take it to the U.S. Supreme Court, we can do that. We've been there. My firm has been to the Supreme Court. I have not, but my partner has.
Right.
And we're prepared to go there. We know the rules, we know the procedures, we can do this. In time, a judge will probably take the position, I'm not going to let you go to trial if all your purpose is to get a pound of flesh. If all you want is punitive relief, not going to give it to you. But if we can then say to the judge or a mediator, this is not the best case to go to trial. You ought to help us to settle the case. Sometimes judges or mediators will do that. And I very recently had a case where I said to my client, no way this case is going to settle. The other side has a lot of money, multiples of the assets you have, and you're not going to be able to fight these people very long. You can fight them for a little while, but not for long. They are beyond rational. They are just crazy, and they want their pound of flesh. We're going to have to fight it. And then, for some reason, we filed a brief and we filed a motion, and the other side had very capable counsel, read it, I think talked to their client. Their client was still just as angry, but I think the lawyers convinced the client, if you don't settle this case, there is a very strong chance you're going to lose at trial. You can take it appeal. You can do whatever you want. You're going to lose every step of the way, and then you're going to be out real money, and you're going to have to pay Mr. Altman's client. So, I don't know all the reasons, but it's settled, and it was very satisfying.
Well, Lou Altman, I've really learned a lot, and the fact is, if businesses here that are in that precarious financial situation that an ABC would benefit. I mean, the fact that that opportunity is there in the state of California, and you're the guy that is kind of the expert in that area. Boy, that's I encourage anyone. Your contact information is on the screen, and Lou Altman, I hope businesses reach out to you, because that just sounds like an enormous advantage. Thank you very much, Lou.
Thanks, Tim.